Hello everyone, I am Rashna Goyal. Welcome back to my channel. Today we will be discussing on PAS-6 filing. Many companies are confused about the PAS-6 filing, to whom it is applicable, when to file, what information needs to be given. So we will discuss that today. PAS-6 is basically a half-yearly reconciliation of share capital form, which need to be filed by two categories of companies. Unlisted public limited companies under Rule 9A of the Companies Prospectus and Allotment of Securities Rule 2014, non-small private limited companies under Rule 9B of the Companies Prospectus and Allotment of Securities Rules 2014, small private limited companies, government companies, wholly owned subsidiaries of unlisted public companies, needy companies are exempt for filing this form. PAS-6 is half-yearly form. It means it is filed twice in a year. For the period ending 31st March, the form must be filed on or before 29th May of the same year, and for the period ending 30th September, the form must be filed on or before 29th November of the same year. In other words, you get 60 days from the end of each of the half year. Before you file PAS-6, the company must have taken ISIN for each type of securities held by the company, be it equity shares or preference shares, and intimate about the facility to the shareholders so that they can get a chance to convert the physical shares into the demand during the half year and even after that. This form needs to be filed for each type of ISIN taken by the company, be it equity or preference shares. However, debentures are not covered under this form. In this form, you need to give details about the company, share capital, which is issued capital, shares held in dematerialized form, either in the NSDL or CDSL, shares held in the physical forms, and the reasons for differences. Shares held with the NSDL and CDSL, they are reporting along with the physical forms. The total of all that should match with the issued capital of the company. Details of the changes in the share capital during the half year, such as due to the bonus issue, right issues, ESOP, private placement, amalgamation, capital reduction, buyback, for whatever reason, there is a changes in the share capital, issued share capital of the company during the half year. It needs to be reported in this form during the half year. Details of total shares held by the directors, promoters, and KMP in the physical and demat form. This needs to be reported in this forms. The very important is that the form needs to be certified by a practicing professional, be it either company secretary or a chartered accountant in practice. So they must properly check the form with the RTA report to avoid any kind of error in filing this form. The most important is that if any company misses to file this form, the directors and the companies both are liable to be penalized under the Companies Act. The pro tip is that take the RTA report, reconcile your company data with the RTA report as mentioned in there, the shares held in NSDL or CDSL with the data of the company, so to avoid any kind of error. If you find this video helpful, press the like button, hit the bell icon, so you will never miss update and videos related to MCA compliances, and share it with your fellow directors, CA or company secretaries who may need this. Drop your question in your comment box. We need